Welcome to Shanmugam IAS Academy. And today's main topic of 8th February 2022 is like women and governance once again. So it's nearly comes under the GS paper 1 of UPSC syllabus, issues relating to women, and also in the GS paper 2 the government policies and interventions for development in various sectors and issues arising out of their design and implementation. Whenever we try to read any topics, anything in the newspapers, we need to connect it with the UPSC syllabus. So we should know what exactly to be studied and how they are very important for our exam point of view. In this way we need to prepare our content. So this comes under these two papers under UPSC prelims, and this is exactly in mains, GS1 and 2 of UPSC mains. So what is today's topic here is sex and violence on marital rape. So this is a burning issue in all the newspapers we know, in Hindu and Express, on marital rape. This is from so many days and so many more than 1-2 years we were studying this news. And why this we are studying exactly now? Because this is in the newspapers. So what exactly the Union government is saying? It actually, the Union government informed the Delhi High Court that it is having a relook at its position on marital rape spelled out over 5 years ago. This was happened five years ago. Now Union government has informed the Delhi High Court they were relooking into this issue of marital rape. So for this only, this was in the newspaper. So we've been studying right now. And Union Minister for Women and Child Development also remarked in the Parliament that the government was engaged in a process to introduce the comprehensive amendments to the criminal law, and that it was considering criminalizing of marital rape as part of it. Why? If you are studying something in the newspapers or something as a topics here, and definitely they might have been in the recent newspapers for some issues, and these are the issues. Not only the Union government has informed to the Delhi High Court, but also here in the Parliament, Union Minister for the Women and Child Development has also remarked that they are in the process to introduce comprehensive amendments to the criminal law, and that it was considering criminalizing of marital rape as part of it. These two were the main issues. For that it was in the newspapers. That's why we are studying and we are connecting it with the UPSC syllabus. So now we are studying on this issue. And what we know about this is exactly about 70% of the women in India are victims of domestic violence. So this is not told by us. This is given by the National Crime Records Bureau, which is a very important body. They said that in this 2019 report that shows that a woman is raped every 60 minutes and every 4 minutes, and she experiences a cruelty at the hands of her in-laws. So this is the report which is given by the National Crime Records Bureau, and also an analysis of National Family Health Survey of 2015 and 16 data, which indicates that it estimated 99% of sexual violence cases go unreported against the men. So this is what the other report. And in one of my editorial I have given the data on the report of National Family Health Survey. So if you want to see that, you can go and watch that video. The average Indian woman is 17 times more likely to face sexual violence from her husband and than from the others. This is what they have told. The average Indian woman is 17 times more likely to face sexual violence from her husband than from the others. This is an important point to be noted. From her husband than from the others. That is why the issue, the marital rape, has came. So what exactly is this marital rape in the definition? So now we will study that. The marital rape is act of forcing your spouse into having sex without the proper consent. This is what exactly about marital rape, and it is an unjust yet not uncommon way to degrade and disempower women. So how does this Indian law regime deal with this marital rape? Now what exact law is there for this marital rape in our country? So one of the most horrifying and repressive issues with the Indian legal regime is that marital rape is perfectly legal in the country. So according to the section 375 of the Indian Penal Code defines that the offence of rape with the help of 6 descriptions. So one of the exception is to this offence is sexual intercourse or sexual acts by a man with his own wife, the wife not being under 18 years of age, is not rape. So this is what under the sections 375 of the Indian penal code. In prelims, there can be a point where this can be a confusing factor. So they can be asked, it cannot be asked, but we need to know about this. One of the exception to this offense is that the sexual intercourse or sexual acts by a man with his own wife, the wife not being under 18 years of age, this is important, is not considered as a rape under the Indian law. And what is the criticism of India's legal regime on marital rape here is that against right to life, and the fundamental rights are also coming into picture here. We are not only studying about the marital rape here, so many fun issues are here, and we are connecting it to the polity too. The fundamental rights are also coming here. What are they exactly? They are saying the criticism is that these are going against the right to life and the right to equality. The Supreme Court has included the sanctity of the woman and freedom to make choices related to sexual activity under the ambit of Article 21. Therefore, that is, this exception clause is the violative of the Article 14 and Article 21, which are prescribed in the Indian Constitution. This is what is told by the Supreme Court of India. And the patriarchal outlook of the laws, what exactly they are saying, the rape laws in our country continue with the patriarchal outlook of considering women to be the property of men post marriages, and with no autonomy or agency over the bodies, they denied married women equal protection of the laws guaranteed by the Indian Constitution. This is what told by, this is the patriarchal outlook of the laws. And what differentiates exactly between the married and unmarried woman? So a married woman has the same right to control her own body as does an unmarried woman. So these are all equal. She also, as a married woman, has equal rights as it's given to the unmarried woman. So unfortunately, this principle is not upheld in the Indian rape laws. For this only, we are exactly studying about this marital rape and how we are connecting it with the political issues and also with the fundamental rights which are prescribed in the Constitution. That is, I've told you about the Article 21 and Article 14. The marital rape is more dangerous to women's life. Rape is rape. Everywhere the rape is rape. The irrespective of the identity of the perpetrator, that is the crime holder, and the age of the survivor. The woman who is raped by a stranger lives with the memory of a horrible attack, and a woman who is raped by her husband lives with her rapist. This is a term which is given and not a threat to the institution of family. The country has adopted a domestic violence law. We know the domestic violence law is there that enables complaints against physical and sexual abuse too. And therefore making the marital rape a criminal offence is unlikely to ruin the institution of marriage any more than a complaint of domestic violence or cruelty would. This is what has been told, and against the international norm. They are also saying, they are criticizing that these are all against the international norm. What is that? Today it has been impeached in more than 100 countries, but unfortunately India is one of the only 36 countries where marital rape is still not criminalized. This point to be noted. So concerns of implied consent, how the concerns and the implied consents are happening. The concept of the marital rape in India has the epitome, the importance of what we call an implied consent. The marriage between a man and a woman implies that the both have a consented to sexual intercourse, and it cannot be otherwise. The Indian Penal Code of 1860 also communicates the same. What is this outdated notion of the marriage? The exception is given to marital rape harks back. The report by the Justice J.S. Verma committee is also noted while recommending its removal to an outdated notion of marriage that treated the wife as the husband property and against the autonomy of married women. Looking at marriage through the lens of the coverture, the view is that the wife is under the husband's authority always, should not be allowed to override the autonomy of married women over the person. So this is what is happening in the country. So Justice J.S. Verma committee also supported that. So what exactly they were saying, that is our penal laws which was handed down from the British have and large been remain untouched even after 73 years of independence. So but English laws have been amended and marital rape was criminalized way back in 1991. So the laws, the old outlaws which was given by British before so many years, after the independence of 73 years, we have not touched, we have not changed anything in that. But English laws exactly in their countries, they have criminalized the marital rape in 1991 way back. So no Indian government has, however, so far shown an interest, either is active interest in the remedifying this problem. So the violation of the UN Convention, what exactly UN Convention is saying, the Section 375 exception of IPC Indian Penal Code is inconsistent with and violative of these principles of United Nations Declaration on the elimination of violence against the women. So they were saying this is inconsistent. This law Section 375 is inconsistent according to the United Nations Declaration on the elimination of violence against women, and that does not pass the test of intelligible differentia here. So what is saying that essentially the Section 375 exception creates a classification not only between consent given by married and unmarried women, but also between married female below 15 years of age and over 15 years old. So such a classification does not pass the test of that is intelligible differentia. Why government is reluctant on criminalizing this marital rape here in our country? So what is why? Because the government is in the opinion that the criminalizing marital rape will destabilize the institution of marriage. This is what their concern, and given the immense of significance institution has in Indian society, so why British they have criminalized this marital rape in 1991 way back. Why India is the because our societal values are very different from the Western culture, and the government also remarked in the parliament that it would not advise that is advisable to condemn every marriage as a violent one. So that is what there's every marriage is not a violent one, and every man is a rapist. So we cannot say this is what the argument given by the government. And in 2016, the government has rejected the concept of marital rape, saying it cannot be applied to the Indian context due to various factors like level of education, illiteracy, poverty, married social customs and values, religious beliefs, and the mindset of the society to treat marriage as a sacrament. This is what the given argument exactly given by the government, because the Western society is completely different from our Indian society. So this is what they have been told in their context. What are the way ahead steps? So in 2017, another government has also opposed the removal of exception in the Section 375 of the IPC that deals with the rape. So what are the way ahead steps here? The criminalizing marital rape in 2013, the UN Committee on Elimination of Discrimination Against Women recommended that Indian government should criminalize marital rape, and the J.S. Verma committee, which I have told you already, has also set up, which was set up is in 2012, is also recommended the same. So judicial guidelines, courts should not indefinitely delay in ruling on the constitutionality of the existing exception in the rape law. So what exactly we are saying here, that is revamping of other legislation. The notion is implied consent within marriage is also reflected in marriage laws that allows this restitution of conjugal rights. So what is that? Thus there is a need of the revamping the whole range of legislation that are continuous with the Victorian morality. So what exactly here this contest we are talking about is, this issue is like quite debatable issues. So it can be, the decision can be taken quite elaborately by considering all the sections of the organizations of this is a, we can say this can be a debatable issue. So here we need to know as a main point of view, so many committee reports are there, such as Justice J.S. Verma committee report, and what UN laws were saying, and how exactly this is connecting it to the fundamental rights of our Indian constitution, and what exactly this Indian law they are not legalized, why exactly they are not legalizing this one. So these are all the issues we have covered in this topic. So if you have any doubts and queries, just tell us in this comment section, and thank you so much for watching this video. Thank you.